Hello students, welcome to Sitaram IAS tutorials. So the topic is Digital Personal Data Protection Act 2023. So the thought of protecting the personal data of the people came from the case called KS Puttaswamy versus Union of India case, because the right to privacy became a fundamental right after this case. Okay, so before 2017 there is no legal provision on the right to privacy. After KS Puttaswamy versus Union of India case, the Supreme Court provided right to privacy as a fundamental right under Article 21. In 2018, Justice Sri Krishna Committee was established to frame the Personal Data Protection Bill. From 2018 to 2023, the bills on personal data protection got extended and it was made many changes, and finally on August 2023, the president has given the accent and the bill turned into the act. So the president has signed the bill and it turned into the act, and that act is called the Digital Personal Data Protection Act of 2023. So the main objective of the Digital Personal Data Protection Act 2023 is it ensures the individuals the right to protect their personal data. Now, before knowing about the act completely, we have to learn four important terms. One is data fiduciaries. So these data fiduciaries are the private and the government entities that takes our personal data for some purpose. Next is data principals. Data principals is we. Okay, if your personal data is with the data fiduciaries, then you are data principal. So all of your personal data is with the government company or the private companies, so you are called the data principal. Next is two important rights we have to learn. One is right to data portability and right to be forgotten. So here the right to data portability. So this right, it allows the reusage of personal data from one IT environment to another in a safe and secure way. Next one is right to be forgotten. So it means that the right to remove or erase the content. Okay, so now this personal data protection bill, this act regulates the data fiduciaries and protects the data principal. Data fiduciaries are the companies which uses our personal data. It may be the private companies or the government companies. So this act regulates the data fiduciaries and protects the data principal. So if there are any data leaks, then this act gives penalty to the data fiduciaries. Okay, coming to the applicability of the act, the personal data that is generated in India can also be transferred to other countries which have government permissions. So our personal data, which is present with Google, Amazon, Instagram and other international companies, is with the other countries. So wherever the parent companies are located, it may be Norway, US. So with the parent companies, our data is transferred to that parent companies. Okay, so here we have one drawback, that is the government has given permission to some countries to store our data, but there is no proper and adequate safeguards and provisions for the data protection standards in other countries. So our data is transferred to other countries. What if in other countries our data is leaked? So standard safeguard provisions and protection measures are not taken. Okay, so this act specified that the data fiduciaries should not use the data for any other personal purposes. Okay, whether it may be government or whether it may be private entities, the data should only be used till where it should be used. Okay, for personal purposes it should not be used. Next is if the data fiduciary have any crucial and sensitive data which may risk the right of the data principal, that is we, which may risk the rights of us, if that data impact on the sovereignty and integrity of India, and if that data risk the electoral democracy and public order, then that data fiduciary is called significant data fiduciary. Okay, it is SDF. Okay, so these data fiduciaries, this SDF, significant data fiduciaries, have crucial information which may risk the rights of data principle, which may impact on sovereignty and integrity of India, all these things. So the big corporate companies like Google, Amazon, etc. come under this criteria because some crucial information is present, sensitive information is present with these corporate companies. So, with these significant data fiduciaries, sensitive information which may risk the country and the rights of data principle is present. So, such companies, in order to monitor and protect the data, should appoint a data protection officer and data auditor for data monitoring. So, because crucial information is present, the data protection officer and the data auditor should be present, should be appointed by these companies. Okay. So, next is for providing government services or for medical emergency, etc., the permission of the data principal is not needed. Okay, so for any medical emergencies or for providing any schemes, government schemes, directly the government gives the schemes without the permission. They take the Aadhaar details, and they, if the money should be sent for the beneficiaries, the government directly sends that money to the bank accounts of the people. So for sending the money, government need not take permission of the data principal. Okay, so the rights of the data principal will not apply in the interest of security and public order of the country. Okay, and for providing government services, medical emergencies, the permission of data principal is not needed. Okay, so all the data of the country is made available to some government agencies, and for some investigations, for some research purposes, for criminal investigations, the consent, the permission is not needed. Directly the data is available to those agencies, research institutions, etc. So here these exemptions provided to the government agencies might be misused. Okay, for the electoral purpose also, the public officials might misuse these crucial data. So it also violates the fundamental right to privacy. So, in case of children also, data fiduciary must not misuse their data for targeted advertisements, and they must not track and monitor the children behavior. So, if there is any detrimental effect on children, then the act penalizes the data fiduciaries up to 200 crores. So, here they directly gave detrimental effect. Okay, so here they did not explain the term detrimental effect, so that's why I didn't change any sentence. So if there is any detrimental effect on children, then the act penalizes the data fiduciaries of up to 200 crores, and if they leak the data wantedly or unwantedly, the penalty of up to 250 crores is levied. So here one drawback is they has specified detrimental effect on the children will be penalized, but here they did not define what the detrimental effect is. So this is one of the drawback. Okay, on children the definition of detrimental effect is not defined. So this, if it is not defined, this also might be misused by the data fiduciaries. Okay, so coming to the limitations of the act, the right to privacy is violated because for some agencies, for some research institutions, the most crucial information, the data is sent. So they might misuse it, and that also violates the right to privacy act, the right to privacy, which is a fundamental right. Okay, so no proper safeguards were made to protect data that is transferred outside the country. And one of the important thing is section 43A of Information Technology Act 2000. So this section of 43A of IT Act tells that the companies which mishandles the personal data of the users should compensate to the affected user. So if my personal data is leaked to other companies or other countries, then that company which leaked my personal data should pay fine to me. Okay, as per the section 43A of IT Act 2000. But um, this section is removed, so now no compensation should be paid. So by this, the companies that mishandles the personal data of the users are protected. So if they remove this section, it is indirectly protecting the companies which mishandle the data. Okay, so this is one of the major drawback. And this act has made the grievance redressal mechanism, that is the problem solving mechanism, very much complicated. And it has made some exemptions to right to information act also. This is also one of the important point to remember. So it has made some exemptions to the RTI. So to protect the personal data of the public officials, before the when we apply RTI of any a public official like public politician, they used to give all the details, including their property details, how much they have earned in the 1 year time period, or 5 years time period. So here this provision has been removed by introducing this act. So before we can know the personal information of the public officials, especially the politicians. So now this provision has been removed from the RTI Act by introducing this personal data protection bill. So it is like safeguarding the corrupt practices. So this is one of the major drawback. And some important rights like right to data portability and right to be forgotten were not granted by this act. Okay, so these are the major drawbacks. Coming to the way forward, while sharing the personal data to other countries, proper regulations should be made to protect the personal data of the individuals. Next one is the data rights, like the right to be forgotten, right to data portability should be provided to the data principals. And there are some specific data fiduciaries which have the country's crucial information, like the significant data fiduciary. So some terms like for them, some terms like sovereignty and integrity of India must be clearly defined to prevent the misuse of this act. So these are the way forward. So that's all about the Personal Data Protection Act. Thank you for watching.